The Spy Uganda, the Spy Television, Detective UG, Andrew Irumba Katusabe, your speaker. I would like to ask you kindly to follow us on our YouTube channel, the Spy Television, Pan-African Pyramid, the Spy Detective, the Spy Uganda newspaper, and Detective UG. Amidst us here right now is Comrade Isaac Ssemakadde. I call him the anti-clockwise thinker, the legal rebel. He is actually the head of Brain Trust. Legal Brain Trust. Counsel Ssemakadde. Counsel Ssemakadde, just something piqued my interest this morning. I got a story. Attorney General Kiriwa Kiwanuka, sixth amendment to law allowing acquittal over torture crimes. Attorney General Kiriwa Kiwanuka has expressed disagreement with the law that allows for acquittal of suspects if they can prove in court that they were tortured during detention. The Attorney General argues that this focus on torture unfairly denies justice to victims of criminal acts. Both the Uganda Human Rights Commission and the Office of the Director of Public Prosecutions support the need to amend the law so that torture is addressed separately when it arises during trial. In other words, to put it in context, right now the law says if you have arrested a suspect of whatever case, but during interrogation or during detention you torture that person, and that case, that matter is raised before the court has to first listen to that torture issue before they address the matter. I want to hear your opinion, Comrade Ssemakadde.
Chidiwachonuka is incompetent and a fool. I have justification.
What did you say?
Chidiwachonuka is incompetent and a fool to say what he said.
Ssemakadde.
Ask me to justify. I am an advocate. I have issued legal opinion.
You want me to?
Those are the words of a fool and an incompetent charlatan. I wrote those words. I wrote those words in the Observer 3 years ago. You didn't read the article. When he was appointed, I informed the people of Uganda in 8 pages.
8 pages?
8 pages.
That is a fool.
Attorney General Chidiwachonuka is the wrong man for the wrong job. Google now.
That is your opinion.
Google now.
That's your opinion.
Because you don't know.
I think the biggest.
Because you don't know. You don't know. That's what a charlatan. That's what a charlatan looks like. That's what a charlatan. Do you know the meaning of a charlatan? A rascal. Because he wears a robe, holds a title in office, you imagine that there is a head there.
Why? Let us address his matter.
I argued in 8 pages. Nobody has answered anything I wrote. Do you know the meaning of 8 pages? 8 pages of commentary going unanswered.
Comrade Isaac, you calm down.
Do you know the point I'm saying?
Let us address.
Don't ask me to calm down or menu.
Let us address the gist of the matter. He's saying, if you have been arrested for a crime and along the way you are tortured.
I have heard. You see, there are 2 paradigms here. There is the speaker and the content. My analysis begins with the speaker. If we do not understand the composition of the speaker, we do not understand the harm in the message and content he has put in the public. So I have begun with the speaker, and I have told you that speaker is a charlatan. You may as well call him a drum.
A drum?
Yes. Once you have understood why he's a drum, okay, then you can understand purely what's wrong with his message. So will you now give me a chance to show you that he's a drum? He's a legal drum, making out of noise and no content. That's what a drum does. He's a drum. The problem is you consider him a pop. He's a drum. And I sued him in court yesterday. We shall talk about that. Yes, I sued him to justify these things I'm telling you. He has confused so many of you.
I'm not one of
who
those
cannot properly bring a critique of a drum, a charlatan, a rascal, just because it has a practicing license. Okay? And some brick and mortar in Colonial. That doesn't make a law. Have you understood? In 8 pages, in an article called "The Attorney General is the wrong man for the wrong job," I argued, I warned Uganda, speaking patriotically, I warned Ugandans, you will see the limits of this fellow. He has significant problems. His own grandfather, Judicial Chiwanuka, was a victim of torture under the Amin regime. His own grandfather. And he cannot pause to reflect on that. He's a drum and a trump.
Those are wrong words.
Those are my words.
In your legal profession, don't you have what they call decorum?
I am speaking as a citizen.
Decorum.
I am speaking as a citizen, and I'm speaking as a citizen with a legal education and training and experience. I know this person.
Okay, now,
I investigated this person, and I complained, and I said he has not been properly vetted. Did you see him being vetted? Did you see him being vetted? He appeared behind closed doors. These questions were not put to him in an open forum. That's why we are discussing them now. It's too late in the night to bring discipline to a charlatan. Now I have finished him. Let's go to the content.
Before you finish him, in your legal profession,
yes.
I know you have something called decorum.
Do not. We finished that conversation last time. I told you decorum, civility, humility, meekness. All those are weapons of power to hold at ransom the oppressed.
Okay, let's go to the content.
Okay?
Okay, I give.
We finished that.
Okay,
you have that content.
Okay.
This is a full debate.
Okay. Let's go to the content, Counsel.
Power masks its violence in decorum. Power masks its corruption in rules of civility. Power masks. Okay? Decorum is the mask of tyranny. Decorum is the mask of exploitation and oppression. So don't tell me about decorum again.
Aye.
We are discussing torture. We are discussing what happens in darkness. Is there decorum in darkness? Is there decorum in torture? Don't be a priest. Be a journalist. Ask the next question.
Okay, the content now. The content. Yes. Contents of his argument. What do you make of? He said
neither the government of Uganda, no branch of the government of Uganda, neither the executive nor the parliament can make a law that can change the rule of the court. The rule Chilewa Chiwanuka and his supporters,
DPP,
a fake DPP.
Everybody is fake.
I have sued her in the South African Court of Justice. She's a fake DPP. Can a judge be a DPP? 2 decisions of the Constitutional Court of Uganda. That's a fake DPP. Okay, go on. And the Human Rights Commission.
Yes.
Have you seen their report? Are you holding a report? It's a commission.
Yes.
It must have written paper explaining this position. Have you seen it? So you receive a press statement and you think that's a commission document, right? You talk about decorum. You talk about decorum. Where is the decorum here? Where is the decorum of those institutions? Why aren't you asking them for decorum? Where is the DPP's position paper?
Okay.
So I am explaining to you the rule that the courts will never try a tortured person is a rule of the court. It's an inherent rule of the court. It goes down to the heart of the legitimacy of a court and a courtroom and a court officer.
Repeat that.
The rule that the court will never try a torture victim is an inherent rule of the court. The court invented the rule. The court itself invented that rule.
It's not debatable.
It's not debatable. The judges will put down the pen and walk away as a union of judges, nationally and internationally. Only a kangaroo court will continue to try a tortured person. That is a rule of common law, a rule that precedes even the government of Uganda.
Hey.
And we inherited these rules as part of, the hygiene of British justice. Do you know that every person picked up and taken to Guantanamo Bay was not tried in America? Why did America take them to Cuba? Because they were arrested and investigated improperly. In America, they would be released on the first day. It doesn't matter that 3,900 people had died under 911. It doesn't matter. The hygiene of American justice system must be protected, not against anybody else but the state, because the state is the owner of coercive power. Okay? It is the owner of collective authority. And therefore it can do most harm. The government has a high duty, okay, to signal proper conduct to the citizen. If the government itself acts in an unruly manner, citizens can't obey law. So, there are two doctrines here that you need to understand. The first one is that the anti-torture rule is a rule of court. It's a rule. It is the rule.
It's not amendable by, because the parliament is the one that.
It is a rule that affirms independence of the judiciary. That judges are independent of government.
It cannot be amended.
It is a rule. It is what we call the irreducible minimum, unpierceable.
Unpierceable.
No use of executive, legislative power can reach it. Not even a judge can argue against it. If they did, they would be in gross error. So this conversation is moot at its origin.
Because you can see deep the Attorney General.
A fake Attorney General.
DPP.
A fake Attorney General. I have sued him to say so.
Suing and winning a case are two different things.
I have sued him.
You have so far sued.
I have sued him, so I stand on my ground, fully in the law.
Court has not yet agreed with you that he is or he is not.
I have brought my grounds for investigation.
Isaac.
Yes, I have incurred the risk of costs. I have incurred the what?
The risk of costs.
Yes, so I'm not an ordinary person like you. You're pocketing. I am not pocketing. I am fighting power. I have caused. I have investigated. Okay?
Right. So pocketing is also a criminal case.
Yes, it's for jokers.
Hey!
Yes.
Hey!
These are serious issues of the people.
Hey!
We cannot be pocketing them while discussing.
In a war.
Yes, we are at war over values of a nation, which were for Uganda in the year 2024. Do we go to the Washwanuka's way or Ssemakadde's way? That's the decision lawyers will make on the 28th of September. Yes, they have been putting nonsense issues on the ballot. We are putting for them real issues on the ballot. Where is your commitment?
Washwanuka or Ssemakadde?
Yes.
So now tell me, what could be the appetite of Kiriwa's thinking that this should be debated or even amended? That someone, even when you have been tortured, beyond losing one leg, you should stand on the other leg and
Empty things make noise. That's what they do.
I don't want to use your...
Empty things make noise.
Kiriwa Kiwanuka is celebrated in Uganda among
Ducks
the
quack.
best brains
Ducks
in
quack.
Uganda, legal brains.
Ducks quack. Cows moo. And dogs bark.
And so?
But lawyers,
lawyers,
not charlatans. Lawyers cite the source of
authority
and recognize the limits of authority. Chiwachonka does neither. He has cited no source of law except the ability to amend the constitution, but he hasn't cited limits to that authority, that we have no authority to take away a rule that is part of the composition of the court. It's like an arm of the court. It's like a limb of the court. It's like a brain, a nervous system of the court. We cannot amend. Okay?
part of your body.
Part of the body. Part of the basic structure. We cannot.
So Kiriwa Kiwanuka is saying, this is a human being, we should amend by removing one ear.
Yes.
That's what he's saying.
And the court should be blind to that kind of violence.
Yeah.
Because we did it in the name of the state, on behalf of imaginary victims. These things are not new. Justice Katusi. in his judgment, which you have conveniently forgotten.
No, I have not.
Do you know what he said about 99 guilty people going free? Why do courts enforce their rules so strictly such that 99 people who are guilty in your eyes can go free? And the court is satisfied with a good job.
Because of torture?
Because the court's rules of hygiene must be kept proper and pure so that those who are innocent have confidence. Okay? That the rules of the game, supervised by a fair and impartial judge, will maintain their innocence through the corridors of court. So the courts are happy to take a report card of that nature. If one innocent person can pass through our system seamlessly, we don't mind 99 guilty people going through the same net, they will be dealt with shortly. But torture, what your Tonka is saying, violates a core principle of the Constitution known as presumption of innocence. No suspect should have their body violated by any agent of the state.
Yet they are simply suspects. They are still suspects.
That is colonial power. That is colonial power.
That is saying that.
That is colonial power. That is apartheid power. But it is simple. I would like to face a citizen arrest under mob justice.
Eh?
Yes. I wish him mob justice. I wish upon him mob justice. Because that is mob justice. That is the same thing.
What he's trying to do is mob justice.
That is exactly mob justice.
So you wish him.
He's using the pulpit of state power
to practice mob justice.
To practice mob justice.
So you wish him what?
I wish him the same. You see, Justice Katurebe has been wiser than all people who have held this office in living memory. He has always questioned those who wish to amend rules around police authority to put themselves in the position of the person against whom they are making a harsh rule. If you put yourself in the picture and you don't like the harshness of the rule, then those are the limits of the rule. That is Katurebe's logic. So would you like to have both his arms removed, legs cut off, and brought to receive a fair trial? We try his torso.
But
maybe we should remove his legs.
You wait a bit.
Kaput. I'll give him a fair trial.
When in the arguments that they had, you were saying,
there is no argument in the noises that you had.
Okay, that's your opinion. Let me now also allow me to say my opinion. In my opinion, the argument they had him put across was that suppose somebody has been arrested having raped a child. Then he comes and convinces the court that I have been tortured. And the court sets him free. This takes away the fair hearing and justice for the rape victim.
Yes.
You have been,
those are the words of a charlatan. Let me tell you very clearly.
What's a charlatan?
Yeah. It will come as a shock to charlatans like Chiwachwanga that under the Constitution, the greatest amount of rights were deliberately given to those who are accused of crimes. They have more rights protection than victims, and it is by design. So it will come as a shock for charlatans like Chiwachwanga that the bulk of the Bill of Rights protection locally, regionally, and internationally for suspects, the bulk, 80% of the Bill of Rights focuses on the suspects having confidence. Do you know there is a rule in the Constitution that says that no trial shall begin without the consent of the accused? A judge has no power to proceed if you don't allow them.
A victim, I mean a suspect.
Yes.
For a court.
Yes.
I have to say proceed.
Yes. We cannot proceed without your consent. And we can't proceed in your absence unless you have given us that consent. So you didn't know this.
No.
It will come because you're a charlatan. It will come as a shock to many charlatans. My brother, comrades.
Because I normally see a ruling.
It will come as a shock to many charlatans. And the charlatan also sit in the judiciary. Don't get it wrong. It will come as a shock to many charlatans that the scheme of human rights has given its strongest protection to those who are arrested
and accused,
detained
and accused,
and presented before trial. It will come as a shock to many such charlatans that the bulk of criminal law and criminal procedure is intended to protect the accused,
not the victim.
Not the victim. Rules for the victims, we are writing them in the modern day. We are writing them in the modern day.
Then that would mean that it is the criminals who sat somewhere and made this rule. And then for us, the same people are
That is good for you to say at the time, because knowledge which is over 4,000 years old has just come to you on this interview. And like an empty team, you make noise.
Me?
Yes, instead of just saying I am surprised, I should read a lot more. I have been brainwashed for a long time.
How can an empty team now?
The noise you made.
How can an empty
So how do you react to
how can an empty team host a brain? How can an empty team host a brain?
So many of us carry empty brains. We even carry big titles like Attorney General. Because we do not hold ourselves accountable to the people. There is a reason why he made those statements at a police compound and not a university setting. He wouldn't have left it alive. He wouldn't. He wouldn't have left it alive.
So you need to invite him to go to Makerere.
Let him dare. Let him dare.
Come to Makerere.
Let him dare. Let him dare go to Makerere University and say those things. He won't walk out of the lecture room alive.
But he's an alumni.
Let him dare. Let him dare. He had to have all these police hooligans around him to speak.
Hooligans? Police officers.
Hooligans.
Police officers.
Hooligans. I use my words carefully. Because they have a constitutional duty of their own in individual capacity to have stopped him from going a step further. They have a duty under the constitution to tell him that, sir, we are independent, loyal to the constitution and not to you. They had to speak either after him and say those are your views and not the views of the Uganda police force. And they are yet to do so. So these are dark times for Uganda. What Chiwachuanuka was speaking about is the law of a police state. Gestapo.
Gestapo.
He is laying the propaganda phase of a police state, for whose interest I warned you in the article. This journey we should have started 60 years ago through decolonization. And then we should have done the demilitarization. Chiwachuanuka is speaking about militarizing the state. The states. So we are sounding a strong warning that there are strong forces demanding of you decorum as they militarize the state. As they militarize from you, they demand decorum. So we are saying no, we shall violate every rule of decorum to expose you. People must see a difference between you and me. The more I keep following your rules of decorum, I confuse the people that we are all the same. The same. It is time to tell Ugandans there is a difference between a charlatan and an advocate. Omufere ne lawyer. Lawyers have been given a vote. They will decide. We are put on the ballot. Yes, and after that, Ugandans will have to make the same decision. Omufere witi the ones. Omufere mu bufuzi eggwanga lyawamuwadde abafere.
So
yes. First and foremost, we shall touch. And then issue command. Baba.
Baba.
Baba. Kamata.
Baba.
Baba.
No touch. At me.
Touch.
Baba.
Train forces.
Hey.
And then issue command.
Command.
Baba.
Unleash.
When courage has gotten, but now there's no courage.
Give me an example of those that you're going to be touching into Baba.
What you want? Yeah, so simple. You will be a very good example to so many other charlatans that have grown up with him. Bumukere de
and
Chiyo wachonuka muzukuru wa Jolly George wanuka ayera bide ebyafayo ebyajajawe tujja mujjukizanga.
Anyway, ladies and gentlemen, I want to end up with a disclaimer. These are views of Counsel Isaac Ssemakadde.
Land friend.
Land friend. I'm not a friend because I'm not a lawyer.
You can say land friend.
I can say, okay, let me borrow. A land friend, Counsel Isaac Ssemakadde. Counsel Isaac Ssemakadde is the head of Brains Legal Trust. Want to get there? And he's also a lawyer for Indoja. He's also my lawyer, my personal lawyer.
So we're having a meeting for you to understand what the Attorney General said.
Yes.
Because you don't want to also be called a charlatan. So this has been your meeting.
Hey.
Yes. So that you are now open-minded and you can go to Chwachwanka and put these views to him.
Actually, before I leave, Mr. Isaac
Nsumikambi Mugambe. Nsumikambi Mugambe.
Comrade is Akiriwa Kiwanuka.
Nsumikambi Mugambe.
I in my own thinking,
the grandson of Jolly George Wanuka.
In my own thinking, I think the framers of that law at that time wanted to deal away with torturing suspects.
It is called international law the duty to prevent. The state, if it wants to be legal and legitimate and a member of a community of law-abiding nations, it must sign up to the UN Charter of 1945 and sign up to the Universal Declaration of Human Rights. It must then sign up to the International Covenant of Civil and Political Rights. It must then sign up to the Convention Against Torture, CAT, and then show proof that internally within its own domestic legal systems, it has put all these agreements into practice by writing a rule that is ironclad protection against torture.
Ironclad.
Ironclad.
Ironclad. If you have to use another word, what would you use for ironclad?
Unamendable.
Unamendable.
An unamendable rule that makes it very clear that torture is prohibited. And it is called the Prohibition and Prevention of Torture Act of 2012. For a reason, two duties. Uganda must go to the UN and show that it has written a law that categorically commands every person in uniform that they have an individual responsibility, and senior orders from above are not defense under that law. Individually, you will take steps to prohibit and to prevent torture and to investigate torture and to provide redress individually, even against your boss.
Hey, the commander-in-chief.
Yes. Even CO, not commander-in-chief. Even CO. Commanding officer. Yes. The commanding officer has no authority
to order you to torture someone.
And it's no defense to say you were ordered. So Uganda, when he first came into office, he went to Geneva to defend Uganda's progress on the same law. The process is called UPR, Universal Periodic Review. We the people of Uganda had reported Uganda for failure to exhibit proper modus operandi. What do you call that?
Against torture.
Against torture. Not just victims. There must be eradication of torture. So there must not even be a threat to torture.
There must not even be a torture victim.
There must not even be a torture victim. So we reported and said Uganda's progress was so slow. And you remember some of our colleagues who were in Geneva they put up a demonstration
against Rio.
Chiwachiwano.
When he tried to defend and
now the funny thing, why is a charlatan? Let me make my point. He was in Geneva. The law he wants to amend is the law he offered as evidence that Uganda is committed to these values.
Hey.
That was just 2 years ago. He offered this law. He offered this law.
He went to Geneva and defended that Uganda is not torturing anybody. Isn't that the point?
And if a person was tortured, they wouldn't even be tried.
Yes.
He cited that same clause.
Now he's saying, if you are tortured, that should be handled separately. We should first hear why.
So which kind of government representative is this one? Who lies at the UN floor and comes at a police compound?
Now he's saying, if you have been tortured.
No, he is saying, I didn't believe the things I said in Geneva. So we must ask, what's the government position? Is it what the Attorney General said in Geneva or what he said in the compound in Kibuli? We must ask. That's what I tell you, is a charlatan, a drum, a head full of porridge.
Mr. Isaac Ssemakadde, have some decorum.
Decorum is the mask of violence. Decorum is the mask of tomfoolery. Tomfoolery. Dimwittism.
Dimwittism?
Yes. He can keep his decorum. I won't. Not under torture. Not when you want to put the whole state under a blanket of torture. When you want to kill the legal profession. So what shall we do then? What results shall we offer in court? Alright? The rule that a trial is stayed. Torture poisons the stream of justice. Justice is a stream. If there's blood in the stream, can we drink? Have I convinced you that Chiwachiwano is a charlatan extraordinaire, a danger in that office?
What I have understood,
and I have asked the Constitutional Court to declare him unfit to hold public office and to declare his office vacant. I have filed that case.
What I have agreed with you is that once a stream is contaminated with blood,
yes,
that water is poured. You
yes,
can't drink that water. What I have not agreed with you,
it's okay, keep it yourself.
Yes, is that he's a charlatan, he's a drum, he's a...
Give your reasons. Give your reasons. Give your reasons.
I have no reasons to call him that.
So what was the purpose of me coming to give you knowledge? What was the purpose?
Knowledge.
Is this comedy for you? I have clearly laid down a whole history of 8 pages you refuse to read. So you say you're going to read and read further.
I appreciate Comrade Isaac Ssemakadde. You have given...
You are the danger when you do not show remorse. The public continue to think that these demigods are acting in the interest of the people. We argued decorum. We told you decorum is a mask of disease. And you're maintaining it. Is it because you can't speak English? Speak Runyankole. What have you learned? Really learned? Speak in Runyankole, leave English.
Let me speak.
This man is a danger. He's a danger. He is issuing what we call a dog whistle.
A dog whistle?
Yes. He's telling the lowest police officer it's okay to torture. It's okay. It's okay. Torture them, don't worry.
Comrade Kiria Akiwanuka, I think the framers of the law were actually trying to prevent that when arresting people, you must not torture them. Once you do that, then you're actually affecting...
You must not even arrest people before investigations have convinced you. So the torture begins when you arrest premature. Once you assure people that they're not under arrest, an investigation is underway, and you respect the rights of movement, it's okay. Okay? Nobody will be tortured. We have to decolonize our elites. Please. Mr. Irumba, Chairman, Pan-Africa. The problem has never been the common man. The problem has always been the privilege, the drunkenness, the corruption, the impunity of power.
Those in power.
And that's why you're the fourth estate.
Yes.
Are you running PR or you're conducting journalism?
I am, as you can see, what am I doing here? What are we doing here? Okay. if you're questioning what I am doing, I think I am doing my job, my role as a fortress. I have had Comrade Kiwanuka's views. I have looked for you with respect to get your views, and I'm very sure our viewers will get a balance.
So make a statement of condemnation of torture now.
Now, me as a journalist,
make a statement of condemnation of torture. It binds all, including the journalists.
No.
You condemn torture or not?
I condemn it.
So say it clearly. Post the camera and condemn torture.
No.
Face it. No debates, no ifs, no buts. Face it. Condemn torture properly. So that those who believe in you understand what is right and wrong. Because they are confused.
I'm not sure.
So you break the confusion.
I am not sure that
condemn torture properly.
I'm not sure that anybody is confused about
don't
my
debate
views.
Condemn torture and condemn torture unequivocally.
Comrade Ssemakadde, I am the host.
Condemn torture.
I am the moderator.
Now you're the when I came in, you didn't know the law. Now you know the law. So condemn torture as a person who has learned something. Or I will never return to your programs.
Ladies and gentlemen, I've come to the end of this show. I think I would like to address two things. One is that Comrade Kiwanuka, the moment you say what you are saying and it is given leeway, it means security officers are going to be torturing people, since it is not anyway going to affect the process of the
it will not hamstring government power. The machine of government will continue to move anyway.
So it means you will have boosted them.
It will reduce judges to just mere colonies of the police.
Mere colonies?
Yes, clerks. Not independent minds.
Comrade Isaac Ssemakadde, yes.
It will reduce lawyers
to what?
To absolutely nothing. And that's not something we'll take like lying down.
You will not take it lightly?
Yes.
Andrew Irumba Katusari, your speaker. This show has got to end. Comrade Isaac Ssemakadde, I wish you well.
Thank you for that firm statement of condemnation of torture and a warning to the charlatan.
28th of September.
We shall see. Inshallah.